Welcome back to the Friday Five for September 29th, 2023. My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Edina, Minnesota and New York City. Today we're going to look at 5 quick questions from the week, FAQ style, about a 5-minute video, maybe things that you've had questions about in the past and things that came up in calls and meetings with clients and prospective clients. Question number 1 this week, should I set up an LLC or should I set up an S-Corp? This is a pretty common question I get, and what you have to remember is when you're asking that question, you're comparing apples to oranges. So an LLC is a type of company, it's a type of corporate form, and S-Corp is a tax election. So if you're creating an LLC, let's say a single member LLC, your choice is between a disregarded entity or an S-Corp for tax purposes. If you have partners, you can also have the option of being taxed as a partnership, and in some cases you may actually be recommended to do an S-Corp election as well for a membership for multi-member LLC. But this shows where it's important to work with accountants so they can understand what your business structure is going to be and what's going to be the best tax classification for you. So remember, an S-Corp is a tax election, an LLC is a type of a company. Question 2 this week, can I make verbal agreements for my LLC? This was a very interesting call I had this week where the caller is dealing with a lawsuit over their LLC. And the LLC has an operating agreement that has specific terms about many different things. The person who's suing the LLC is also claiming there were verbal side agreements about things, and that based upon those verbal side agreements, he was suing the LLC and was entitled to money and an interest in the LLC, actually. So when we have this kind of situation, the first place we have to look is actually that operating agreement. So if somebody's making a claim that they're a member of your LLC and they say you have a verbal agreement that Andrew agreed I can be a 25% owner of the LLC, well, then we look at the operating agreement. And if you filled one out and signed it and you made sure that everything is proper, that's going to hopefully have a provision that says to admit a new member, here's what has to happen. We have a set process that we have to go through so that that verbal claim from that supposed LLC member isn't going to stand up in court unless you've gone through the actual process in the operating agreement. However, if you don't have that operating agreement, you may find yourself in a lawsuit and you're fighting over whether or not, inequity is what we call it, whether or not this person is an equitable member of your LLC and is entitled to some kind of interest in it. So it's very important, if you have an operating agreement, that we follow the rules that are set up by that agreement. And if you don't have one for your LLC, now's a great time to get started and get one put in place. Question 3 this week, can I buy a business that doesn't have an operating agreement? So another operating agreement question came up this week, and you can always buy an LLC. You can buy a business that doesn't have their shareholder or operating agreement, but it's not something I would recommend that you do. If you're going to buy it, you'll probably want to do it at a discount because you're not sure exactly how that company's been operating. We want to make sure who the actual members are of an LLC or the shareholders of a company. And that operating agreement and shareholders agreement will usually have a provision for how the sale can take place, how the company can be valued, all of these different items that we need to take care of whenever we're selling a business. So if you do buy a business that does not have an operating agreement, my next suggestion is always going to be, once the sale is over, get an operating agreement in place so that down the road, if you choose to take on investors or you choose to sell the business, we have that operating agreement in place, that shareholders agreement in place to make sure we have a process so that you can get the best price and get the best investment for you and your business. Question 4 this week, should I update my will after my husband files for divorce? This is kind of an oldie but a goodie. We get this all the time. So if you and your spouse are married and somebody's filed for divorce, we want to check your estate planning documents and make sure they need to be updated. Make sure to see if they need to be updated, sorry. So in this case, the wife had actually already done an update after the husband had filed for divorce, and the documents were pretty straightforward. What they were doing was making sure the children were taken care of and cutting the husband out of the estate if something happened to her while the divorce is going on. So I always recommend after a major life event, if there's been a death, if someone's getting a divorce, if someone's getting married, if a child or a grandchild is born, when these major life events happen, it's very often a good time to reach out to your attorney and check to see if your estate plan needs to be updated. And question 5 this week, should my estate be the beneficiary of my life insurance policy? In 99.99% of the cases I see, the answer is going to be no. The reason is if you have a big life insurance policy, let's say you have a $10 million life insurance policy on your life and you leave it to your estate and you die, well, that $10 million can be counted for the estate tax if you're in the right state. or I guess the wrong state as it were. And in a couple of years, that federal exemption is going to go down to about $6 million unless the law changes. So that $10 million life insurance policy could unfortunately leave a significant tax legacy for your family. This is the power of the beneficiary designations. So what happens with the beneficiary designation is those funds go directly to the person who is designated as the beneficiary. If you say my estate is the beneficiary, that means that the money has to go into your estate, meaning you probably have to open a probate now with your local court. You don't always have to open them depending upon how your estate is planned for, but having a $10 million life insurance policy, or frankly even a $1 million life insurance policy, can create the need to open a probate estate with your local court, leaving more work for your family that you may not have intended for, where some simple beneficiary planning and working with a financial advisor can make sure you don't have to worry about these issues. So that's our 5 questions for the week. If you liked the video, hit the like or the thumbs up button. You can subscribe to future episodes on YouTube. You can submit a question for future episodes at the link below. You can always go to 𝙁𝙊𝙇𝙊𝙒.com. We can set up a legal strategy session to discuss these questions further. You can find me at Ayers Law on social media. And wherever you are, I hope you have a wonderful weekend.